At trial, when the judge says objection sustained, what happens if the witness goes ahead and answers the question anyway? What happens then? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now, let's say this is a medical malpractice trial. You sued your doctor claiming that he was careless and that his carelessness caused you significant harm and injury. The doctor disputes every single thing that you claim. And plus, he says, hey, by the way, your injuries really are not as bad as you claim them to be. So now they tell us, hey, listen, we're never going to settle this case. We're never going to negotiate. We'll see you at trial. And you say, fine, we'll see you at trial. Well, that means you're going to go through the litigation process, which is going to take you 2 to 3 years to go from the start of the case all the way up to trial. And now you finally get to trial. Your attorney has your medical expert up on the witness stand. He's the expert who confirms, number one, that there was wrongdoing by your doctor. He confirms that the doctor's carelessness was a cause of your injury. And he confirms that your injuries are significant and, in fact, permanent. So now, during the course of questioning, your attorney asks a question to your own medical expert. He's the one supporting your case. And now the defense attorney jumps up out of his seat and says, Your Honor, that's an improper question. And the judge says, objection sustained. Now, what does that mean? It means that the question is improper and that the witness is not to answer the question. Let's say the medical expert didn't hear what the judge said, or he didn't understand what objection sustained meant, and then went ahead and answered the question. What happens then? Well, the whole point was the question was improper, the answer never should have been given, but now the question was asked, the jury heard it, the jury heard that the question was improper, the witness didn't hear it, and now went ahead and gave the answer. What happens next? Well, I'll tell you what happens next. The defense attorney is going to jump up again and say, Judge, I object. You sustained this objection, yet the witness still went ahead and answered the question. I asked for a corrective instruction to the jury. So now what will happen? The judge will turn to the jury and say, ladies and gentlemen, you are to disregard that question, you are to disregard that answer. That question and that answer is not to play any part in deciding whether this injured patient is entitled to a verdict in her favor. So now the judge is trying to give a curative instruction to tell the jury, listen, that was improper, you should not have heard the question, you should not have heard the answer. Now we've addressed it, let's move on. Now what happens if the attorney asks a similar question that calls for a similar answer? Well, that's the goal. You want to get out certain information, and just because the defense lawyer has objected to the way the question was asked, known as objection to form, or he's asked a question that he thinks is improper, does not automatically mean that you're prevented from going ahead and asking similar questions. The whole idea is that I, as an attorney conducting a questioning of a witness, especially one that's favorable to us, I need to get out certain information. I need to establish liability, I need to establish causation, and I need to establish damages. All three of those things have to be confirmed by our expert. Just because the defense has objected to a particular question does not mean I'm prevented from asking it many different ways. A good attorney, you'll find that good trial attorneys can ask a question not just 5 different ways, but 10, 15, 20 different ways. Because if they get an objection one way, hey, guess what? That doesn't stop me. I now ask it a different way. I'm now going to ask it a different way, or focus on a slightly different topic that ultimately is going to bring me back to the question that I need to ask. And even if I do get an objection, at some point the judge will likely turn around and say, okay, objection overruled, which means defense lawyer, that's not the right objection. The question is proper, and now the doctor can go ahead and answer that question. So why do I share this great information with you? I share it with you because it's a beautiful day today here in Great Neck, and I wanted to share this great information because, in all likelihood, you're watching this since you have questions about your own matter that happened here in New York. Well, if your matter did in fact happen here in New York, and you have not yet started a lawsuit and still have questions about your matter, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.